The trial to decide who is the rightful heir to succeed the late King Zwelithini between King MisuZulu and his half-brother Prince Simakade Zulu continues at the High Court in Pretoria. Members of the royal family supporting Prince Simakade Zulu's claim to the throne say they're confident that they have enough grounds to challenge King MisuZulu Zwelithini's right to the throne. The case was postponed in May. This is after the king requested a postponement on the basis that he was still waiting for the late AmaZulu traditional Prime Minister, Prince Mangosuthu Buthelezi, to submit his affidavit. Let's listen in.
President for legal recognition as the king of AmaZulu. Now that's very critical. That means the president understood the legal position that only the royal family could submit that at the duty to identify an heir or a successor to the king. And then he says, from the above correspondence, it would appear that there are concerns surrounding the nomination of the king-elect. I therefore request you to attend to this matter in consultation with KwaZulu-Natal provincial government and advise me accordingly. But the minister then responds and obviously commissions what is called a mediation panel for AmaZulu kingship dispute. But let me pause there. At that very moment, that letter reflects that the president was aware that there are concerns regarding the identification of the second respondent. The concerns were not just, they had gone beyond concerns, because now there was a formal complaint by Princess Tembi Ndlovu. So at that very point, we submit that the president had one cause of action. And that cause of action was to then appoint which the Act says is yes. So my Lord, I'm referring here to Section 8(4) of the traditional of the. I must find a shorter way of. But anyway, I have time. Traditional and Khoisan Leadership Act. Yeah, that's probably longer than saying Traditional and Khoisan Leadership Act.
Is there any act to be referred to? Because if not, then you just say the Act.
Yeah, the Act. Okay, then I'll just say the Act, my Lord. So, my Lord, so it's 8(4) of the Act, which says that where there is evidence or an allegation that the identification of a person as a king or queen, and I'll leave it there, was not done in accordance, was not done in terms of customary law and customs, the president or the relevant premier, as the case may be, may cause an investigation to be conducted by an investigative committee. Now, my learned friend, Mr. Dodson, and I deal with that extensively in our heads of arguments. My Lord, and perhaps...
The point is there's no choice.
Yes, it's a mandatory requirement. The moment there is a dispute, or there is evidence or an allegation, and saying an allegation is even lower because, you know, evidence may complicate a bit more, but allegations is simple. All the president needed to have in order for this power in 8(4) to be triggered was an allegation that there has been non-compliance with the law that governs the identification of a successor. And we say that the president had ample evidence of that. His own referral of this matter to the minister, to be dealt with by the minister, was an acknowledgement of that particular issue. My Lord, then you will see, my Lord, that we say right there at 8(4), the president failed to perform a mandatory legal requirement. Right there at 8(4), the president failed because while the president is entitled to seek advice or to consult with the minister and the premier, and I'll leave the issue of abdication of duty to my learned friend who deals with it with more commendable clarity than I do. the consultation between the president and the minister is a consultation that does not interpose the process that was interposed in this instance. In other words, when the president says, please help me with this, give me advice, because that's what he asks for. He says at the end of the letter that advise me accordingly. So he was seeking advice from the, and we'll go to that advice, my lord, to see that that my learned friend's argument is very potent, that there was an abdication of duty when the president received the letter from the report from the minister. What then happens, my lord, is that the minister commissions this mediation panel, and we don't particularly take issue with the fact that the minister decided to approach it this way. We think that if the minister wanted to gather more evidence for purpose of advising the president, perhaps that was the route that he could take. But we do point out that the mediation panel route is not a legislated procedure. In the face of a statutory duty for the president to conduct an investigation, it appears to us that where the president recognized that there was, in fact, a dispute that triggered his Section 8.4 powers, that an investigation was the route that the president would have had to follow. But then, of course, the minister then appoints 3 eminent people to deal with, to conduct whatever they were conducting, but it appears their mandate was to mediate. Now, that's a very, 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 very important mandate, but not one which is recognized anywhere, in custom or in the legislation. My lord, the report of the mediation panel appears on page 026/3. Now, I'm not sure whether it's in this Simakade or, but your lordship would find it there for purposes of whether it's in the Simakade or in the Prince Simakade or in the Prince Mboni's application, that record appears on those pages. And my lord, it's important to go through this report because this report tells you something about the royal family when they are allowed to speak freely about a matter as important as who should be the next in line on the throne. Because the mediation panel or the mediation panelists conducted interviews with different members of the royal family, and it is at that time when you realize actually there is justification for a dispute. In other words, it was clear that there was a dispute. The dispute was such that when the panel concluded in its paragraph 6, which is on page 02643, I refer in particular to clause 6.2. It says divisions exist within the royal family over kingship. Dispute resolution interventions therefore justified. And then here is 6.3. Huge disagreements on the legitimacy of the process appointing Prince MisuZulu. Divisions exist on the process of submitting Prince Simakade's name as contender to the throne. Disagreement also exists on who is the legitimate core royal family and invited members of the family in the appointment of the king as defined by the law. And then it says Prince MisuZulu has been recognized as king by the side that supports the nomination and is being greeted accordingly. Mercifully, my lord, in this courtroom there is no side that supports Prince MisuZulu. He's on his own, and he's come here to this court to defend his own interests.
So that was a submission made by
So, my lord, in the court papers that your lordship will have regards to, it's clear that Prince MisuZulu, who is the current king, is here in his own right. He's here to defend a decision which was made by the president. He's not representing the royal family, he's representing himself. And you will see that, my lord, because if you go to, I will just find his affidavit, my lord, and then we'll come back to the issue of what he says under oath, who he represents. And that will probably clarify the issue a bit better. But my lord, then what happens is that when the minister has finalized, when the ad hoc committee finalizes the report, that report is given to the minister. The minister examines it. My lord, I pause here a little bit because I do want to consider whether I've dealt sufficiently with what the contents of the report is. And I'm trying to, as I stand here, find an intelligent way of just going through it without having to go through page by page, because it's quite telling of the nature of divisions that were identified by the royal family. But my lord, the upshot of it is that when in close.
Isn't it quicker? I know you say one must have regard to one of the report, but if you say rather than go page by page, then one has the recommendations at the end. And is 7.1 where the minister and president are advised to wait for full cases to conclude? That was at that time referring to the matter before Madondo AJP.
Yes, that's correct.
And once that concluded, well, then the recommendation is that you can go ahead and then rely on what was said in that matter. That's when the president can have.
Yes. My lord, here is the submission that in fact, I was going to that very point, my lord, that perhaps I should just go to the recommendations. When the advice of the ad hoc panel is that the president must await the court cases to conclude before proceeding with any other action, it's something your lordship has to bear in mind. It is not for the court to identify an heir.
No, that is so. But Madondo AJP sought to answer the question not whether who was identified. That in paragraph 78C says the issues raised by affidavit are whether the Prince MisuZulu was legitimately and appropriately identified and nominated as the successor to the national seat.
Yes.
And that's what he answered.
Yes, but
parties before him at that stage.
In fairness, your lordship, you point me correctly to what the judgment says. And I accept that what Madondo did was not to identify an heir, but was to validate an allegation that an heir had been identified by the royal family on the 14th of May. Yes.
As an adjunct to that, he also answers the question on the papers when it was before him whether there was a dispute as to the kingship or not.
Yes, and he says that there isn't. That's how we see it, which we say was completely incorrect for the judge to say that.
Well, apparently that still stands.
No, it doesn't stand, my lord. Let's resolve this. My lord, when the president is advised.
Let's deal with like this on what he found the complaint was at that stage. He found that there wasn't a dispute.
Yes, that's what he found.
Have a look at the other correspondence. There was a dispute. Even the mediation report indicates that there was a dispute.
That's yes.
And then you say that triggers sufficiently because it's qualified as an allegation, and it sufficiently triggers then Section 8 for mandatory statement.
That is correct, my lord. But but I take it further than that, because the judgment of His Lordship Madondo is on appeal. It is before the Supreme Court of Appeal on two fundamental issues. The first issue is whether the marriage of the applicant in that case is the only marriage, because there was an issue with one of the queens was asking that the marriage be recognized as the only legitimate marriage. But the second one is whether Justice Madondo, by virtue of having played a role in the royal family, was in fact qualified to sit in the application. Both those matters are before the Supreme Court of Appeal. I know that there is a view that they are not there. That is the basis of this res judicata point, which I'll deal with in a short while. The outcome of the Supreme Court of Appeal, in fact, before you even get there.
Yes, but that's also, bear in mind, the matters before him were heard together, almost consolidated because of similar factors.
Yes, that's correct.
The will issue, which you dealt with first.
And referred to the trial.
And referred to trial is one thing. The other matter in 10879 of 2021 was for an interdict to interdict the coronation.
Which was dismissed.
Undertaken by events.
Yes.
So, what part of his judgment is then still, there's a dispute whether it is on appeal, but what part of his judgment can then still be appealable? The first part, not, that's a referral to evidence.
Yes.
The second part's been overtaken by events.
Yes. No, remember, my lord, what happened there is that there was a rumor that in December a coronation was going to take place. It was a rumor. And I accept that there was when the
Allegedly scheduled for 3 December.
Yes.
Of 2021, yes.
My lord, let's just look at what the Supreme Court of Appeal is likely to come up with. If it sets aside the judgment of Madondo on the basis that he was conflicted, he had conducted one of the marriages of the queens, he had been involved in the royal family quite closely. It doesn't save any aspect of that judgment. But before you even get to that, my lord, once the judgment of Madondo of Justice Madondo was appealed, Section 18 of the Superior Court Act kicked in. Once that happened, kicked in, which means that judgment is suspended until such time the Supreme Court of Appeal has dealt with it. Any reliance on it is really not rational. And that's the point we raise in respect of the President's recognition in the face of being told by the royal family that they are going to appeal that judgment of Madondo. So we say the matter is before the Supreme Court of Appeal. We have to absolutely respect that, because we don't know how the Supreme Court of Appeal will deal with it. And that's the whole idea of appealing a judgment, that an appeal court must be given the opportunity to deal with aspects it considers triable within the scope of the appeal.
Let me just understand. On the issue of the interdict application, you say that you want the Supreme Court of Appeal to find that the longer HAP was conflicted.
No.
And it was wrong to have not given an interdict, but now events have already taken place.
No, that is not what I'm saying, my lord. Your Lordship would know that's not a competent argument to make. I'm not making that argument. It wouldn't be. Perhaps to help your Lordship, it wouldn't be
Once the Section 18 application is blocked, I should ignore everything that Madondo HAP has found.
Yes. Because Section 18 specifically says that when an appeal has been noted against a judgment or an order, in fact, it's important maybe to actually refer to that section so that. No, my lord, I know that you know the section, but it's just also for my own clarity as I make my arguments to your lordship, because I can see that they may well be.
No, I was trying to follow your argument. So you said, well, ignore what all the HAP, but we were dealing with the report of the mediation of Section 8. And then you made some comment about what he said, and I said, well, he found there wasn't an objection. And then I said, but you now say, irrespective of what he found, and irrespective of the appeal issue, what was before the President was an allegation of a dispute.
Yes.
You referred that to the Minister. The Minister referred that to a panel. The panel made recommendations which says that there was a dispute, and there were divisions, and there's a medium to long-term mediation process, and wait for the court case first. That's how they got to the court case.
Yes.
The recommendation of the report.
That's correct, my lord.
And then chronologically, let's deal with it is on your argument only relevance for chronology. Report from mediation committee.
Right.
Wait for the court case. Court case was done. President says, "Thank you. I've seen your report. I've seen the decision. I'll now go ahead and do the recognition decision and the coronation follow."
Yes.
Or other.
Yes, that's...
Right, so that's the relevance of it in your argument.
Yes. Well, no. So my lord, perhaps I should understand your... Because I just said yes, because I was trying to run through what you just given to me. The relevance insofar as the president is concerned is that when he's advised that he must await the outcome of court cases, there are two court... Remember that what Justice Matondo says is that the one case, the dispute about the wills will go to trial. I just made the submission that the royal family would be absolutely, they would revere the view of the late king. If that will is authentic, it points towards the direction that it ought to be pointing out. So it's important for their own deliberative purposes. It's now in a trial. So in a way, what the president did was to conduct himself in a manner that deprived the royal family of the right to fully engage with all the matters that ought to inform how the identification process is conducted. In other words, he refers the issue of the will to a trial. We don't know what the trial is going to say. Trial might say this was an authentic will. It's worse if the trial says this was a forged will, because then the royal family must engage with how this happened, why it happened, and it is deeply relevant to how the royal family might consider that particular aspect. But the second issue is that when the royal family, when the ad hoc mediation committee refers or advises the president to await the court judgment, that's interesting advice, because this nature of this dispute was invariably not going to end up with Justice Matondo. So that's just it. And I'm sure, my lord, I'm not trying to say anything more about the prospects of where this judgment, your judgment, your lordship, is going to go. But it's such an...
Also, first instance have that difficult...
Yes.
Sword hanging over them.
Yes. So there's this Section 18 process, and the president had been told, and had been told before... he had been told that if the judgment of Matondo comes, I'll get back to that later, but he had been asked not to recognize the second respondent because the royal family was going to appeal the judgment of Matondo. I'm just picking it up from a rational decision-making process that involves a matter as sensitive as this one. Was there any pressure on the president to identify the second respondent? In the face of being told by these applicants before you today that, Mr. President, we are going to appeal the judgment of Matondo. The time frame for the appeal is I think it's 20 days if I recall my procedural law correctly. But there was enough time when the decision was actually made. And you'll see from the chronology that the advice that that the president got came from two angles. The first one was the advice that came from Prince Buthelezi in the letter of the 12th. The second one was the minister herself saying that on the basis of the judgment, he now supports the identification of the current king. Now, it's even interesting because one looks at it and says, but how can the executive say on the basis of a judgment? Shouldn't it be on the basis of the royal family decision the basis is not a court judgment. The basis is the decision of the royal family. And my lord, perhaps can I speculate how that would have turned out? The first would have been the judgment of Justice Madondo comes out. It says what it says. The royal family embraces it and says we're not appealing it. So it says what it says. The president says, well, I now have a judicial finding that sets out the road path for me to identify. But there is an important part that one has to have, an application by the royal family. That application is mandatory. So the royal family would decide it and would say, well, we have a judgment, we endorse its findings, we think the judgment is sound, we want the president to appoint or to recognize the person that is referred to in the judgment. He's our son, these are the qualities, and this is why we think Justice Madondo is correct. That doesn't happen.
That's now your second point.
Sorry?
That's now your second point. Initially you said the 3 points is did the royal family identify as accessors? Secondly, did the royal family deliver an application? And third, did the president consult with the minister and the premier?
Yes.
You've now slightly gone on with the president's consultation, but you've now referred to the application. Is that now the formal point?
Yes, that's the other ground.
Yes. You say there was no formal application by the royal family as such, as you say, to say this is the king-elect and these are the reasons.
Yes, in fact, what happens, my lord, is that the president is specifically told by the members of the royal family that there is going to be an appeal. And my lord, perhaps I should refer to that letter.
Without stealing
It
Mr.
appears-
Dodson's thunder.
I beg your pardon, my lord.
Without stealing Mr. Dodson's thunder.
No, without stealing Mr. Dodson's thunder. I definitely don't intend to do that, but my lord, so there are two letters of critical importance that your lordship, I would refer your lordship to. The first one appears on page 006-94, and that's the letter by the attorneys of the royal family as represented by the applicants here, which set out in commendable detail why the president should not identify any successor at the time. I might refer you, my lord, to paragraph 11 of that letter. It says, we request the honorable president to communicate with us by close of business on Friday, 11 March 2022, first to acknowledge receipt of this letter, and second, to convey to the honorable president's attitude towards giving our clients the opportunity that is necessary for them to resolve this weighty constitutional matter prior to considering the recognition of any person as king of AmaZulu. They ask the president, they say, please give us an opportunity. The president ignores them. But then there is a letter, the earlier letter, which I thought I had here. Sorry, so there's also an earlier letter, which is the letter of the 21st of February. And my lord, you'll see that letter, that the first applicant explains why the identification has not been done. And he says that there are many rituals that have to be done, amongst others.
Is that the letter 006-98?
It's 006-98, yes.
98, yeah.
So that letter, my lord, is very critical because you'll see at the end what he says. Just under conclusion, the royal family has great respect for the AmaZulu throne. The Zulu royal family has great respect for the Zulu culture, customs, and practices. The Zulu royal family vows to honor the legacy of His Majesty, the late King Zwelithini, and his predecessors by ensuring that their wishes are upheld in matters of succession to the Zulu King. His Majesty, the late King Zwelithini, trusted the Zulu Royal Council through appointment and council to do what's best for the royal household and the AmaZulu nation. So you'll see that the president was constantly being told by these applicants that he must wait and not act on recognizing the second respondent. And then the letter of the 12th came, which was the letter from the late Prince Buthelezi, which was addressed to the president. Now, this is very important, my lord, because you'll have seen that the Act specifically tells us when it's dealing with the application, it says that when it deals with the application, it says under section 8.1 A, Roman numeral 2.
Apply to the President or relevant minister, as the case may be, for the recognition of the person so identified as king, which application must be accompanied by particulars of the person so identified, the reasons for identification of that person.
Yes.
That's what you're to refer me to?
Yes, that's what I'm referring to. But you'll see here, my lord, that there is the letter of the 12th is titled Coronation of His Majesty King MisuZulu Zwelithini. One would have expected that if it was an application under section 8, that it says application for the recognition of Prince MisuZulu Zwelithini. But you'll see there that the letter is essentially one that tells a story of how the king is already on the throne. And we're now talking coronation. We're not talking recognition. We're talking coronation. That's why the title is Coronation of His Majesty. But importantly, the second paragraph of the letter says, His Majesty King MisuZulu Zwelithini was recognized by the royal family on 14 May 2021, following the reading of the will of Her Majesty Queen Mantfombi Dlamini Zuma, the late regent of the Zulu nation, on 7 May. Perhaps, my lord, the important part now is for me to show that the reliance on the meeting of the 14th, which, by the way, His Lordship Madondo left open. His main finding there was no one has challenged the validity of this meeting of the 14th. This application does so. So it didn't deal with the allegations that are here, that are made out in this particular application. And you would have seen, my lord, that that meeting of the 14th was a meeting. Can I have that meeting of the 14th? Please refer me to the meeting of the 14th. My lord, I beg your pardon. I just want to add a bit of a senior moment there. But the meeting of the 14th was a meeting we contend was called under the pretext of firstly, it was a day when a cleansing ceremony had taken place in relation to the passing of the late Queen. On that very day, then the late Prince Buthelezi says, I thought it would be a good idea for us to meet because most members were present on that particular day. We say in our application, so what you'll see is that there's a list of people that are allegedly members of the royal family who attended that meeting. But we have shown, my lord, in response to that meeting of the 14th, that should never be trusted as reflecting a meeting of the royal family. It was not called by the royal family. It was not a meeting that was an identification meeting of the royal family. You will see from the minutes that you have there that all that happened was that someone was the meeting was opened. My lord, I've got a MisuZulu version for it, and I don't want to read that one because for the record, I do have the English version of it. My learned friends here will help me with that. But so that meeting could never be a meeting that represents the royal family as defined. In the first place, there is not a single person in this courtroom today saying that, validating the meeting in the sense of saying, yes, except the second respondent. Yes, I was there in the meeting. This is what happened, and this is what happened, this is what happened. Not one person says that here. They may be in the courtroom, but they're not in the papers. So there no confirmatory affidavits, my lord. No confirmatory affidavits for anybody in that meeting, saying this is how it was called, why it was called. We make specific allegations about that meeting.
Can it still have been a meeting even though it followed on the cleansing ceremony? Does it necessarily have to be a separate meeting?
If it's a meeting of the royal family designed to carry out this sacred duty of appointing a king, why put it together with the cleansing ceremony? The Zulu royal family would know better how you structure that particular meeting. You could never just mix it with any other day. It's so important, my lord, when they select a king, that there shouldn't be any other event on the day, especially an event that links to the death of a member. My lord, that meeting, you'd have seen that it was, it says, it's on page 020-273. Well, I'm opening where it starts, it's 020/272. And you'd have seen that the chairperson of that meeting was Prince Mangosuthu Buthelezi. There's a great debate between the parties about the status of Prince Mangosuthu Buthelezi to sit as a member of the royal family and preside over the issue and direct the affairs of the royal family insofar as the identification of a king is concerned. And your lordship would look and find not a single affidavit in this application that, in terms of which Prince Buthelezi makes it clear that he is in fact entitled to chair meetings of the Zulu royal family and to direct their affairs insofar as they want to identify a successor to a king. We're not going to, and my lord, this is a difficult argument to make because I do want to have reverence for Prince Buthelezi's passing away without compromising my client's case. There is a great deal of unhappiness in the royal family with the role that Prince Buthelezi played, and you'll see much of that in the panel report itself. That people who, when Prince Buthelezi wasn't there, and they were asked to speak frankly and openly about what was going on, they were very clear about what they believed his status was. And they did not believe that he had the status to direct the affairs of the Zulu royal family, particularly those relating to the successor to the late King, His Majesty Goodwill Zwelithini. You'll see, my lord, there, under purpose of the meeting, Prince Buthelezi welcomed all members of the royal family, reserving all rights protocol. But the more important part is that expressed appreciation for the presence of all members of the royal family from their respective palace and for assuring unity. Prince Buthelezi introduced the new incoming king of the entire royal family as Prince MisuZulu Zwelithini Zulu. Introduced.
Sure, but it goes further. He referred to the president, and then he refers to the reading out of a letter by Prince Simakade. Prince Simakade. Yes, the other applicant. And then he goes on to say, once again nominated. And then there is then the comment from other members of the royal family from paragraphs 5 and 6, words of thanks from the Queen, and then the comments by other members. So one must read the whole document, I think, and not only the announcement.
No, in fairness, my lord, I'm still on the podium, and I'm still going through my arguments. The suggestion that I'm trying to read half of the paragraph is not a fair one.
I just say, when one reads the document...
Oh, I see what you mean.
read it
Yes.
as a
No,
document.
understand.
No, I'm not suggesting.
Understand.
My
My Lord,
doing anything improper. No. I just say that when you refer to the fact that he comes and he introduces it, and you say, well, you shouldn't have done that. You're not a member of the royal family, and besides, he hasn't even been identified yet. That's wrong. But one should read the document as a whole and say, well, how far does that go then?
Yes. But even the second question you asked, my Lord, how far does it go read in the context, the whole document? Can it ever be suggested? And the first question, if he's not a member of the royal family as we define it, then that immediately vitiates the entire meeting. Only the royal family is entitled to call a meeting of that nature. And the royal family is before your lordship today. So you'll find nowhere in history where Undunankulu of the nation is the one who decides who should be king. And perhaps let me go to what our replying affidavit, in the affidavit of Prince of the second respondent.
Just refresh my memory.
I have it here.
Refresh my memory. Is that letter of Prince Simakade next to this minute? It's at a separate page.
The letter of Prince Simakade is attached to the. It should be attached to that minute. Can I have the replying affidavit of our replying to Simakade to Mrs.
It's at a separate page, not next to this translated minute. But that was
Yes.
the one. Was that the one which Madondo AJP referred to?
The letter of Prince Simakade is the one that Madondo refers to, yes, where he says Prince Simakade abandoned his right to be
disavowed.
disavows his rights. I use a strong word, my lord, but I see your point. My lord, in our heads of arguments, we deal with the reason why that meeting of, in fact, we dealt with it in the other, I just can access it quicker in our heads of arguments, and we deal with that from page 032.5 of our heads in the on case line. And you'll see, my lord, just going through the whole our heads on the issue. We were very meticulous in how we tried to identify the members of the royal family referred to as having been present in the meeting of the
14th of May.
Of the 14th of May. And you'll see there, my lord, that there was a number of people who were not members of the royal family present in that meeting. Yeah, Bazinj. I will then take your lordship to page from paragraph.
Are you now referring to your
34.
heads of argument?
Sorry, my lord.
Are you referring to heads of argument?
Heads of arguments, yes.
Yes.
Paragraph 34. That's a list which appears in many times in different in our heads of arguments. As we say there, he has attached a list of attendees at the meeting, and we're referring to the second respondent called by Prince Buthelezi. But a clear examination of the list supports the conclusion that this was not a meeting of the royal family convened for the purpose of identifying an heir to the successor. From the list with handwritten information, that's your annexure KM8. The details require a full name, surname, institution of house, telephone number, and email, and then the signature only. There are two attendance registers. The first counts up to 51 attendees, and the second counts up to 84 attendees. In the first attendance register, the date of the register is typed 14 May 2021. But in the second register, the date is inserted by handwriting. It is unclear why the list was created, except as we contend it was for COVID regulatory purposes. There is no evidence that the list of attendees was created especially for the purpose of identifying the responsible members of the ruling family or royal family. This is important because of the different roles that members of the royal family at different levels play in the identification process. And then there's a third list which is typed, which purport to interpret or replicate KM8. The type list is a distorted reinterpretation of the handwritten list. The type list groups the attendees according to the so-called lineage from the attendees alleged come from.
Yes, no, that's good.
And it's important, my lord, because can I just do this, because it's very important that it's understood. Right now I'm talking to you, your lordship, as a court case, but you understand the interest in the matter is far beyond what I say in the courtroom. And can I just go through, with your permission, my lord, what we identify here as having been the problem, because if your lordship decides that the matter should go back to the royal family, these are the issues that should engage them as they decide with the issue. And I do want to point out in the list which is contended by the second respondent.
You say it's been adjusted fraudulently to make it
Yes,
a grouping
it is absolutely
of representation of certain of the houses constituting the royal family.
Yes, and I did want to go through that, because some of them will know that there are no royal houses of the nature that are referred to. They don't exist. And that's important, as you can hear, my lord. So,
well, I have that from the heads, and I don't want to curtail your argument, but what I understand from the heads, you say the argument is there are no such houses as identified in the regrouped list.
Yes.
And
for example, my lord, there is no house called Wapindangene in the royal family. There is no house like that. But it's listed. There is no royal in the royal family. There is no house.
all right. No, I've seen that. Thank you. And you've gone. There's a list in the heads of argument. It appears that there's.
My lord, I do need protection.
I'm not going to rely on the difference or disagreement displayed in open court. I'll rely on what has been said in the paper.
My lord, the sensitivity of this matter is such that it will be very important for your lordship to get everybody to understand the role I play. I have no personal interest in the matters of the royal family.
No.
I just argue my client's case.
Yes.
So I would like everybody to know I'm not here representing myself.
Yes.
So
You're an officer of the court representing a client and
Yes.
advancing the argument which has been made in
Yes.
affidavit.
Yes. I mean no insult to anybody. I mean no disrespect to anybody. I just want to make it myself clear that I act for these applicants who are members of the royal family.
Yes.
On their advice, on their instructions, certain names that appear as houses, or houses of the royal family, which are listed in the meeting of the 14th, don't exist.
They say they don't
Yes.
exist as houses, or if they exist as houses, not as houses of the royal family.
Yes.
No, I understand.
They are not
that.
relevant. They would not be relevant for the succession issue. They would not even be present to discuss anything of the royal family. And then, my lord, we also point out.
Let me just out loud say what you've now said, which is correct. That counsel argues a matter on the papers and representing his client. And I shall deal with what is said and weigh up what he has argued on evidence, on what other applicant or respondents has said in evidence. But we need to do the argument in the proper manner. And when counsel argues, he argues that proposition. And I cannot and should not and will not be allowed the argument then to be dictated by disagreement in court.
My lord, perhaps I should leave it at the point of saying I refer your lordship to our heads of arguments on the meeting of the 14th. But we emphasize that meeting of the 14th was not a meeting of the royal family. We say that the late Prince Buthelezi is not a member of the royal family, was not entitled.
I think those attending court didn't hear me clearly earlier. Is that I will rely on what counsel says, and the parties who are represented here have their own legal representatives, and I need to hear what they say and attach sufficient weight to what they say and not to disagreement in court.
Lord, I don't wish to be discourteous, it's not in my nature, but I was wondering whether it wouldn't facilitate this hearing if your lordship would grant me the indulgence of a 5-minute adjournment to explain exactly what your lordship is saying.
You're going to do that in
To the
MisuZulu?
gallery.
Yes. Perhaps that's a good idea. Mr. Masuka?
I have no objection to that.
Court will adjourn.
Because you don't have this.